Hey, how's it going, gang? Nate on the Stone here. Welcome back to my channel. You know, sometimes events just happen that make you go full Charlton Heston.
You maniacs! You blow it up!
Now, in our instance, we don't have a nuclear holocaust, we just have the Supreme Court. The future will decide which one was better. Last year, I made a video where I asked a very simple question. Was the Supreme Court going to legally abolish biological sex? I asked that question in the context of the case Harris Funeral Home versus Equal Employment Opportunity Commission, which was going to decide whether the funeral home firing funeral director Anthony Stevens after he announced that he was going to start dressing at work as a woman and identify as Amy violated Title VII of the Civil Rights Act of 1964, which decreed that it is illegal to discriminate on the basis of sex. The odds were definitely not in favor of a logical ruling, which would have been, no, it doesn't violate Title VII at all. We are talking about the institution that just 5 years ago snapped its fingers and uncoupled marriage from its 10,000-year-old definition, just so that Anthony Kennedy would have a chance to write really bad poetry disguised as a legal opinion. Nevertheless, there was a shred of optimism in my soul. After all, we are talking about biological sex now, something so obvious, so in our face, that even a blind man can see it. Surely an institution, even one as fossilized by ideology as the Supreme Court, would be able to see that.
What are you, nuts?
Or it just single-mindedly kept following its ideology like a train headed right for hell. What did Heston say again? In Bostock versus Clayton County, Georgia, which combined 3 different cases, the court ruled that yes indeed, firing said male funeral director did discriminate on the basis of sex. Writing the majority opinion for the 6-3 decision, "I've got to be living in some sort of alternate reality," Justice Neil Gorsuch wrote, quote, "An individual's homosexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Consider, for example, an employer with 2 employees, both of whom are attracted to men. The 2 individuals are, to the employer's mind, materially identical in all respects, except that one is a man and the other a woman. If the employer fires the male employee for no reason other than the fact he is attracted to men, the employer discriminates against him for traits or actions it tolerates in his female colleague. Put differently, the employer intentionally singles out an employee to fire based in part on the employee's sex, and the affected employee's sex is a but-for cause of his discharge." Justice Gorsuch apparently hasn't been keeping up to speed on his gender ideology homework. Not that I can entirely blame him on that front, because it does have a habit of changing on the turn of a dime, because the idea that our biological sex is somehow attached and connected to orientation and identity would probably come as a surprise to gender ideologues, and probably be termed as some form of oppression. The genderbread person and the gender unicorn were both created specifically to teach kids that sex, orientation, and identity were all completely separate and unattached. It's why sex is being replaced with gender assigned at birth, since, don't you know, we don't know how a newborn baby is going to eventually identify until he gets older and can actually tell us. If he survives gestation and birth, that is. Oh, and FYI, old now apparently can mean as young as 1 year old now, because according to San Francisco-based psychologist Diane Ehrensaft, a 1-year-old assigned male who unsnaps his onesie and waves it in a particular way is making a quote-unquote pre-verbal communication about gender. Furthermore, we've been told now that sex itself is not really a category, but more like a spectrum, with people not being entirely male and not being entirely female, but instead amphibious creatures that are just more male or more female than others. Hey, it was in Nature magazine, so it's gotta be true, damn it! Which actually leads to an interesting question. If sex itself doesn't exist anymore, then how can you discriminate on the basis of it? That's one technical problem with this ruling. Another one is that the example that Gorsuch used, firing a male employee because he likes to date men, but not firing a female employee because she likes to date men, is obviously an example of sex discrimination, doesn't hold water. Oh, it looks nice when we initially hear it. It sounds fair and commonsensical. But when we put on the old thinking cap, it all falls apart. In this case, Robert P. George, the McCormick Professor of Jurisprudence at Princeton, provided the thinking cap for us. Professor George, back in November, wrote a whole piece in National Review where he tore apart this faux example after it was first used by Justice Elena Kagan. She provided this so-called test for discrimination. A company that fires a woman who dates women, but which would keep her if she was a man who also dates women, is obviously discriminating on the basis of sex, if everything else remains the same. But as Professor George pointed out, you can't magically change the sex of a hypothetical employee and keep everything else the same. If Sarah is a woman who dates women, but she's magically transformed into Samuel, who also likes to date women, then more than just the sex has changed, the orientation of the person involved has changed as well. Professor George said that the only equivalent to Sarah dating women would be Samuel dating men. But in that case, Samuel will be fired just as equally as Sarah, which means that there was no discrimination based on sex to begin with. These are all good reasons to go over to show why this Bostock ruling was such an abomination. Unfortunately, it doesn't get rid of the fundamental fact that the Supreme Court, the highest court in these United States, legally abolished sex. By saying that the funeral home could not fire a male director after he began dressing and identifying as a woman violates Title VII, it equated identity with biological sex. By saying that an employee fired because he practices homosexuality violates Title VII, the court said that orientation was the exact same thing as biological sex. In other words, the court did in Bostock what it did in 2015, changed the meaning of a word in order to attain the desired result. And we've already seen where that leads us. Since 2015, we have seen the rise of open marriages. Utah has actually decriminalized polygamy, and women now marry themselves, marry their dogs, or heck, even marry 91-year-old candelabras named Lumiere. Marriage went from having a solid foundation to being an amorphous blob in a sea of amorphous blobs where it could mean whatever the heck you wanted it to mean. And now the same thing has happened to biological sex. The fundamental dichotomy of our species that has made history, culture, anthropology, and everything else in the human sphere possible, including, I might add, reproduction, which is kind of a basic necessity, has now been airbrushed by 6 of our 9 Olympians in black robes. And the best part is that wasn't even the only decision that the court graced us with. In refusing to hear an appeal regarding a Ninth Circuit Court of Appeals ruling, which said that California's sanctuary cities are completely constitutional, the court said through its silence that municipalities can absolutely break federal law, providing, I'm guessing, that they break the right laws for the right ideological purposes. In ruling that the Trump administration could not terminate President Obama's DACA program, which everyone agrees was illegal to start with, the court made it very clear that while one president can create and operate an illegal program, another president cannot actually undo that illegal program. So the message is that the law of the land maintains that it is illegal to undo an illegal action. This raises a whole lot of questions. The first one being, what does the law even mean now? You know, what's really fascinating about the Bostock ruling is that the plaintiffs were upfront that in 1964, when Title VII was debated and passed by Congress, sex meant biological sex. It didn't have any connection with orientation or identity. It didn't matter. It was still going to be redefined today in 2020. In his dissenting opinion, Justice Alito described this brilliantly as a pirate ship, under the flag of textualism, the idea that a law should be interpreted according to how people generally understood what that law meant when it was passed. The court claimed for itself the power to update the laws in order to align them with quote-unquote our current values of society. Now, if that's the new norm, there isn't even going to be anything that we can objectively call the law. As we talked about a few weeks ago, law, according to my man Cicero, is right reason in accordance with nature. That's why an unjust law, a law that revolts against both reason and nature, isn't even really a law at all, as Martin Luther King Jr. pointed out in his letter in the Birmingham jail. But now the court has actually done one better. It has said that there is no law outside of what the elites say is the law. Elites who control and who dictate what our values are and what they aren't. This in turn breaks the entire fabric of society, the present, learning, drawing, building from the past for the future, putting us again at the mercy of whatever powers that be, which happen to be in charge at any given moment. Following from that comes the question, in this new environment, what protections do we even have under the law? If the laws are at the mercy of a cultural elite which decides what our values are and what our values aren't, what we're really saying is that the will of our cultural elite is the law. And if that's the case, what we're saying is that we don't have a system anymore where everyone is equal underneath the law. Instead, we have a system, an animal farm, you might say, where, of course, everyone is equal. Just that some people are more equal than others. And if we're not in that 1% of cultural elites, then basically we're just living on a bed of quicksand. At any given moment, any one law can be twisted, revamped, reshaped in order to align it with our quote-unquote current values, which themselves are now almost constantly changing as intersectionality, critical race theory, and identity politics change their goals. To give just one example, Sky, a British Comcast-owned pay-per-view service, just decreed that Disney's 2019 abominable live-action remake of Aladdin has outdated cultural stereotypes and language, even though the entire point of making that movie, besides making a quick buck for the mouse, was to make the Aladdin property more politically correct. If something can now become outdated 13 months after its release, then my comparing our situation to a bed of quicksand is way too apropos. And finally, why should we continue to obey the law? That's not a rhetorical question, gang. I'm serious when I ask that. If municipalities can break federal laws that they don't like, if the executive branch designed to enforce the law can't undo what everyone knows is an illegal program, and if we have no protection under this new system of law, why would we continue to give the law our allegiance? What's in it for us? We could say peace. Breaking the law will not only bring the powers that be directly down upon our heads, but it will also break the fabric of society. If everyone is breaking the law, we're not going to have order, we're not going to have justice, we're only going to have chaos. And as we've pointed out many times before here on The Stone, if you have chaos, you can't have a society. But here's the $64 question, gang. Are we really at peace? No. I would say that we're not. Not in this new environment that we find ourselves in. Not in these new cultural and legal circumstances, which sooner or later will turn its gaze directly on to you. The Declaration of Independence says that prudence dictates that as long as evils are sufferable, we should continue to be good citizens. However, when a long train of abuses and usurpations that have as their direct end an absolute tyranny over our lives, then it is our right and duty to chuck off that system and to provide new guards for our future security. Food for thought. But as always, what say you? Are we now approaching a point where evils become insufferable? Or is this just another stupid Supreme Court decision in a long line of stupid Supreme Court decisions, which will pass away as most of them do? As always, let me know your thoughts, ideas, and comments in the towel box below. Well, that about wraps up everything for right now, gang. Before you go, if you could give the video a like and share it with your friends on social media, I'd be very much obliged. And if you like videos like this that tackle culture, politics, and religion from a unique POV, then subscribe and tickle the bell for notifications so that you will always know when I post new videos like this, videos that you're not going to want to miss. As always, thank you for watching, for giving me a little slice of your day. Thank you to everyone who has already subscribed. I appreciate you all. Until next time, gang, remember to dare to read, think, speak, and write. I will talk to you soon. Ciao.